In the meme stock community, crimes against shareholders are considered especially heinous. On the internet, the dedicated retards who investigate these crimes are members of an elite squad known as the Project Popcorn Unit. These are their stories.
Why is that so funny?
Good evening, ladies and gentlemen. Okay, the court calls this cause number CV2300179. Adam M. Is it Aron?
Aron.
Aron versus Nelson Willis. Applicant versus Nelson Willis. Respondent. Now, is applicant present and ready?
Yes, Your Honor.
Where's the applicant?
Oh, Mr. Aron is not here today. We submitted an affidavit.
And by whose authority did you think you could come in here and submit evidence by affidavit?
Your Honor, we did not clarify that with you.
I'm not allowing you to. No one asked permission of the court. And
Your Honor, we followed the Texas criminal statute relating to protective orders. It did not mention...
Where? I'm not allowing you to submit evidence by affidavit. Show me where you can present an evidence by affidavit for the final hearing, not a temporary ex parte protective order.
Your Honor, I'm only aware of Article 7B001, the application for...
Say again?
The authority I'm aware of is Article 7B001, application for protective order.
7B. Where are you looking?
It is in the Code of Criminal Procedure, Title I.
I have it printed out, Your Honor.
No one asked you a thing. You can present affidavits on the temporary ex parte protective order, 7B101. What section?
So it's 001, and this relates to the application, Your Honor.
For the ex parte order?
This is the only section of this chapter that's dealing with the protective order application for protective order under Title IV of the Family Code. And if you'll go to the Family Code, the only protective order that can be issued by affidavit is the ex parte. Oh, wait. I'm sorry. I read you. Sorry.
Sorry. In the same manner as an application for protective order under Title IV of the Family Code, and if you'll go to the Family Code, the only protective order that can be issued by affidavit is the ex parte.
Your Honor.
That's the original ex parte without a hearing.
Your Honor, the Family Code, we did not think applied in this situation.
At any proceedings related to an offense under 42-072 in which the defendant appears before the court, a person may request the court to issue a protective order under Title IV Family Code for the protection of the person. The request under subsection A is made by filing an application for protective order in the same manner as an application for protective order under Title IV Family Code. The court shall issue a protective order in the manner provided by Title IV Family Code if, in lieu of the finding that family violence occurred and is likely to occur in the future as acquired by Section 85-001 Family Code, the court finds that probable cause exists to believe that an offense under Section 42-072 Penal Code was committed. The nature of the scheme or course of conduct engaged in by the defendant in committing the offense indicates the defendant is likely in the future to engage in conduct prohibited by Section 42-072 A1, 2, or 3. The procedure for the enforcement under Title IV Family Code applies to the fullest extent practicable to the enforcement of a protective order under the chapter, including provisions relating to findings, contents, duration, warning, delivery, law enforcement, duties, and modification.
Under the Article 7B, when you go to Section 003, that sets out the issuance of the protective order. There's also another subsection within Article 7B that talks about when the title, the family section, would apply. I cannot remember off the top of my head which one it is. I don't have that one printed. It might be 008 or...
The court shall issue a protective order in the manner provided by Title IV of the Family Code. Well, I'm telling you that I'm not going to issue a permanent. I think that you're wrong. You could prove me wrong. So far you have not. But I'm telling you that I'm not going to issue a permanent protective order by affidavit.
Yes, Your Honor.
The consequences for a violation of a protective order are too serious. I believe that he's got the right to confront his accuser. I don't need any help from you.
I assume there's an interjection at that point.
Is there an interjection? Is there something there?
No, it's not in the actual transcript.
Somebody was like,
Oh, okay. I don't need any help from you.
It's like,
In a court of law. So there's the right to confront his accuser in the court of law. So the applicant will have to be present in this court if he wants to pursue the protective order. I do not give permission for this to be submitted by affidavit. So we will postpone, and it will give him the opportunity. But one thing I need to make very clear to you, Mr. Willis, based upon what you have attempted to file in this case, this hearing will only be about the application for protective order. This is not your opportunity to engage in any kind of civil lawsuit against the applicant for breach of fiduciary duty or anything about your issues with him with regard to diminished value of a stock or anything to do with stock. Stop making me laugh.
I'm sorry.
Okay. This is a whole nother issue. It has nothing to do with whether or not you have committed the offense of stalking him. You understand that?
I do, Your Honor.
The only issue in this court is should I issue a protective order against you for your conduct? If you can prove to me that you have engaged in, if they can prove to me that you have engaged in stalking and whether or not I should issue a protective order, have you engaged in stalking? Is it likely you will continue to engage in stalking? That's the only issue before the court. So I'm going to require him to appear in person. So we will reset this. I would consider perhaps allowing him to appear by Zoom unless there's a reason not to, but not by affidavit. This does not give him the right to confront and cross-examine his accusers. So we need to reset. Yes.
In regards to my communications with the petitioner.
Who?
With the petitioner, with the applicant.
Yes.
My only communication with him. Okay, let me start by saying.
Okay, I'm not hearing this case today.
Well, I'm a congestive heart failure patient. Okay, and the date of this, I'm a shareholder. I'm not. I'm not a stalker. Okay, I'm a shareholder.
Okay, Mr. Willis, I'm not hearing this case today.
Well, I'm just going to say one thing. My emails were to their investor relations, and then they ignored me because of the shareholder vote on March 14th, and I was in the hospital that day.
Okay, I'm not hearing the facts of this case today.
Well, I'm just saying that they're to come at me outside of the actual shareholder, and they're trying.
I'm not hearing this case today.
Well, they're trying to silence me as a whistleblower to the SEC, and that's a. And
further, there's a proposed order that's been submitted that wants me to include no further communication to the SEC. That is beyond the scope of this protective order.
Yeah, that is against.
I don't need your help.
My constitutional rights.
Don't need your help.
Yes, ma'am.
Who's the coordinator?
I guess
I'll do it.
Yeah,
we can do it on August 7th, 11 a.m. or at that afternoon. Oh, on the next person too. We have time. Okay. May I get a few dates to be able to discuss with Mr. Aron?
May I say one last thing?
Just a moment.
We can also do it almost any time on the 8th, and we have quite a bit of availability on the 9th, and really the rest of that week we have time. Your Honor, with your suggestion on potentially we may be able to do it via Zoom, do we need to do a formal request with you for that?
Yes.
Okay.
Mr. Willis, are you opposed to the applicant appearing via Zoom?
I am worried about witnesses that attending via Zoom or what have you.
Do you have witnesses to whether or not you sent the emails?
I have lots of them.
That whether or not you sent the emails? I don't want to hear anybody that's going to talk about
No, okay.
the stock.
My emails are not about Mr. Aron as a person. They're about him as a CEO.
Well,
And that's what this whole thing is about.
that's not the issue. The issue is, did you send the emails to Mr. Aron?
As a shareholder and exercising my shareholder rights.
I don't care if you sent them as the Easter Bunny.
They are strictly.
Did you send them?
It is my shareholder right to communicate with the CEO. The CEO actually.
It is not your shareholder right to communicate in vulgar, threatening, or harassing manner.
That's First Amendment of the Constitution. My first free speech.
Well, you can argue that next time. Okay, so reset.
Okay, so we're going to.
We'll set it for August 7th. At what time?
We're going to continue?
Don't interrupt me.
Yes, ma'am.
What time?
2 p.m.
August 7th at 2 p.m. Unless we hear that right now it's set August 7th at 2 p.m. We're adjourned. We'll see you back August 7th at 2 p.m. As of now, all parties in person.
Oh.